Disclaimer. All I am is a paralegal, forensic investigator, and analyst. I do not know it all. No human does. This is my research and findings in my investigation of a horrid event. If you don't like what I've found, join the club. I don't like it either. If you don't believe what I've found, conduct your own investigation. If you owe any lawfully created government agency any lawful, properly assessed tax, my recommendation is for you to pay it. This country needs for all of us to watch much less TV and study how to bring it back to God through the person of Jesus Christ.
Hello, folks. This is video number 3 of 8. This is counts 1 through 12 of the indictment. On July the 11th, 2006, Kent Hovind was charged with violating 26 U.S.C. 7202, willful failure to withhold and pay tax. 12 quarters over 3 years is what's charged against him. So 4 quarters a year, 3 years, total of 12 counts. The next 5 panels are the first 5 pages of the indictment filed solely against Kent. As you read it, please make a mental note of willfully on page 4 because it will be brought up in later panels. So here's the indictment. Notice here it says in general. Here's page 2. I'm not going to read this entire thing. You can pause if you'd like to and read it. I want you to see on page 2 that they are stating that he failed to file Form 941, and that they also have defined Dinosaur Adventureland as a children's theme park. On the next page, I want you to see that they're again charging him with failing to file Form 941, and that they have accused him of failing to pay over tax that was withheld from employees' wages to the IRS. And here's page 4 of the indictment. And notice there it says willfully failed to deduct. And then in page 5 you'll see that this is all in violation of Title 26, United States Code, Section 7202. So they have alleged something like $376,000 in taxes in the previous 5 pages that they're saying that he withheld but failed to pay over. But then in other places they say he failed to withhold it. And so we have a bit of a conflict there that should have been discovered but apparently wasn't. So let's go to panel number 8. Notice there at the arrow on page 5 how the 12 counts are all alleged to be in violation of 26 U.S.C. 7202. Now that's one statute. If there's no fraud, that would mean that these 12 counts would have to stand, but if there's any fraud, then all 12 of these counts must be reversed. Let's go read that section 7202 of Title 26. Here we go. Willful failure to collect or pay over tax. Any person required under this title to collect, account for, and pay over any tax imposed by this title who willfully fails to collect or truthfully account for and pay over such tax shall, in addition to other penalties provided by law, be guilty of a felony, and upon conviction thereof shall be fined not more than $10,000 or imprisoned not more than 5 years, or both, together with the costs of prosecution. This statute contains no self-execution language, but does have some vague terms that makes us have to search for specificity elsewhere. First thing I want to do from here is check to see if this statute has any enforcement regulations. So we have to go look and check. That place to look is the CFR. Next is a copy of the cover of the Code of Federal Regulations Parallel Tables Index. And there it is right there. The next page, just inside the cover of this book, shows when it was most recently revised and published, and the 2 stamps show when the book was received in the library where I made the copies from it. You can see here, this is a depository library at the Fondren Library Center in SMU Dedman School of Law. And the latest copy that I read was received on May 4th, 2015, and they're in the Law Library May 19th, 2005. The next page shows this book is an official government edition and in its very first paragraph requires judicial notice of its contents. This makes it self-authenticating per the Federal Rules of Evidence 902. And there it says, shall be judicially noticed. And down at the bottom it shows the Government Publishing Office. The next page shows the table of contents, and we're going to be looking for the parallel table of authorities and rules beginning on page 899. And there you see the parallel table of authorities and rules, page 899. Page 899 states, quote, the following table lists rule-making authority for the regulations codified in the Code of Federal Regulations, end quote. Here's another quote within that page. Within each segment, the citations are arranged in numerical order for the United States Code by title and section, end quote. So those are right there. There's where your quotes are taken from on that page, 899. So going to page 947 shows the list of Title 26 USC statutes beginning at section 6303 at the top of the left column, and it ends on the page in the second column at section 9002. Now look between section 7122 and 7207. There is nothing there. It skips directly from 7122 to 7207. See here in the top, we're in Title 26 USC 1986 Internal Revenue Code. And there at the bottom, between 7122 and 7207, there's nothing there. And here it is enlarged. This shows the absence of any matching enforcement or implementing regulation for 26 USC 7202. It would be right there if it existed. So what does this mean? It means that in absence of legislatively granted self-execution language, combined with the absence of any enforcement regulations, 26 USC 7202 cannot be lawfully enforced. Remember the case law of U.S. versus Rennis, Varbell, Anzalone, the 200,000, the Richter, the California Bankers versus Schultz case, the Murphy and Mirsky cases? There must be regulations and its language, and even the intent must apply to the actual activity for there to be prosecutable criminality. Recall the former case law that stated that the statute was amplified by its regulation. It also said the statutes and regulations are so inextricably intertwined that an interpretation of the regulations necessarily is a construction of the statute. Are there any other case laws that support this specific premise that a statute must have matching enforcement regulations for the statute to be lawfully enforced? The answer is yes. In Merton's Law of Federal Income Taxation, Section 3.56, it is revealed that the absence of regulations means that the section is not intended to be implemented. The authorities cited for this proposition are U.S. versus Farrar, that's a U.S. Supreme Court case, and Mintz versus Baldwin, also a U.S. case. Internal Revenue Manual, Exhibit 4.26.5-4, year 2001 through 2004. Another verification to this tenet of law is the same Internal Revenue Manual 4.26 at the exhibit list pages at the end of the manual for the year of 2001 to 2004 regarding non-bank financial institutions, which were at that time exempt from being enforced against in the anti-money laundering program because no regulations had been written yet. So here's the quote. Quote, non-bank financial institutions generally are exempted until regulations are issued. 67 Federal Register 21-110. See also 31 CFR 103.170, now 1010.205. In other words, no regulations equals no enforcement. Here's Dodd versus United States 223 Fed Sup 78. For federal tax purposes, federal regulations govern. Recall the former case law quote from the California Bankers case that stated, we think it important to note that the Act's civil and criminal penalties attach only upon violations of regulations promulgated by the Secretary. If the Secretary were to do nothing, the Act of Congress itself would impose no penalties on anyone. This means we're going to have to go somewhere else to locate a specific requirement to find out exactly who is obligated to withhold and who can be lawfully penalized for not doing so. Factors to consider are, what are the key turning point words in the statute? Let's look for them by reading the statute again. What does it say? Any person required under this title. How does one become required under this title? It is automatic. Is it automatic for everyone in America? Are there any exceptions to this applicability? So here it is again, 26 U.S.C. 7202, willful failure to collect or pay over tax. Any person required under this title to collect, account for, and pay over tax imposed by this title who willfully fails to collect or truthfully account for and pay over such tax. Okay? See that word required? We are looking for someone who is doing a government job as some kind of an unpaid agent. We will now focus on the requirement to withhold and use the Boolean word search engine in the Cornell Law website to locate and see exactly what conditions are required for withholding. Next is what I found when I searched for the three words withholding, agent, and required. That search took me to 26 U.S.C. 7701. Here it is, and it's all definitions. There's 50 in the list, but 2 of them have been repealed, so that leaves 48 definitions. We're going to focus on, instead of reading all 48 definitions, we're going to focus on the 3 pertinent ones. Number 4, domestic. Number 5, foreign. And number 16, withholding agent. So here they are. The term domestic, when applied to a corporation or partnership, means created or organized in the United States or under the law of the United States of any state, unless, in the case of a partnership, the Secretary provides otherwise by regulations. Foreign is number 5. The term foreign, when applied to a corporation or partnership, means a corporation or partnership which is not domestic. And then withholding agent, number 16. The term withholding agent means any person required to deduct and withhold any tax under the provisions of Section 1441, 1442, 1443, or 1461. Okay, the first 2, domestic and foreign, are pretty simple. Domestic means an organization created in the United States, created under the laws of the United States or under any state, unless the Secretary of Treasury wants to expand partnerships broader. And foreign means non-domestic. Now let's focus on the withholding agent definition. Number 16. The term withholding agent means any person required to deduct and withhold any tax under the provisions of Section 1441, 42, 43, or 61. Now that seems kind of strange that a definition should be this specific, but this is what Congress passed, so we're going to go with it. First up is 26 U.S.C. 1441 in that list of the 4 statutes that withholding agents are required to withhold from and hand the money over to the United States. Who is withholding required on? I want you to be asking yourself that question. 1441 says withholding of tax on non-resident aliens. Very interesting, eh? There's the link there at the bottom if you want to go read it yourself. So I checked the Code of Federal Regulation Parallel Table Index, CFR-PTI, and found that 26 U.S.C. 1441 does have enforcement regulations, and they are listed on the next page, and they too are strictly for foreigners. There it is, 26 CFR 1441. So I went back to the statute definitions list, 26 U.S.C. 1442, and looked it up, and here it is. Who is withholding required on per 7701A16? 1442, withholding of tax on foreign corporations. I'm not going to read that whole thing. It's all about foreign corporations. Wow, more foreigner withholding. Are we ever going to find any domestic withholding? Let's check to see if 1442 has any enforcement regulations. Yep, here they are. Withholding of tax on foreign corporations, exemption under a tax treaty, and tax-exempt income of a foreign tax-exempt corporation. Yep, 26 U.S.C. 1442 has enforcement regulations, all for foreign corporations and foreign tax corporations. Let's check to see if withholding applies to domestic people in 26 U.S.C. 1443. Oh, there it is. Foreign tax-exempt organizations. A and B. Here it is again. Foreign tax-exempt organizations must be withheld on and the money turned over to the United States. Next is the regulation for 1443. Foreign tax-exempt organizations. I'm not going to list it. It's really long. That's just the title, and that's all it's about. Okay, that covers 3/4 of the statute definition in 7701A16. The only one left is 1461. Maybe that is where the mandatory withholding for domestic workers is at. Let's check. Okay, this is 1461, liability for withheld tax. Every person required to deduct and withhold any tax under this chapter is hereby made liable for such tax, and is hereby indemnified against the claims and demands of any person for the amount of any payments made in accordance with the provisions of this chapter. Okay. Now, there's no mention of the word foreign, but there is a requirement to deduct under what? This chapter. So what is this chapter? Well, it's chapter 3. So now we got to back up in the website to find the title or the name of chapter 3. And here it is. Chapter 3, Withholding of Tax on Non-Resident Aliens and Foreign Corporations. Subchapter A is for non-resident aliens and foreign corporations, and subchapter B is with application of withholding provisions 1451 through 1465. Now here's the chapter title. Every person required to deduct and withhold any tax for non-resident alien and foreign corporations is hereby made liable for such tax. Chapter 3 contains 2 subchapters, which are A and B, and the 1441, 42, and 43 are in subchapter A, and 1461 is in subchapter B. All of the statutes found in subchapter A and B apply to withholding strictly for foreigners or foreign entities, both for-profit and non-profit. See that? Here's your proof. They're both subchapters under Chapter 3, which is titled Withholding a Tax on Non-Resident Aliens and Foreign Corporations. Examine this closely. There is nothing in Chapter 3 that deals with withholding for anyone or anything domestic. And I checked the CFR PTI to see if there were any regulations for 1461, and they are shown below. Again, they are for foreign entities and contain no domestic withholding obligations. So I contacted Kent Hovind and I asked him directly, have you ever hired any foreigners to work at Creation Science Evangelism? And Kent emphatically said no. I asked, have you ever hired any foreign corporation or foreign nonprofit to work for you or CSE? I got the same answer, no. So I kept searching. I found that there are 2 government documents that if one applies for a benefit or a title to an unpaid office, and if that application gets approved, then they would become obligated to withhold according to contract law. They are the Forms 2678 and the SS4 shown next. These completed forms require it. It's 2678 over here on the left and SS4 on the right. You can't see the arrows where the arrows are pointing at, but when we enlarge them, you're going to see what I'm trying to show you. Let's look at Form 2678 more closely. Notice the list of forms that the withholding agent would be obligated to file if they applied for and were granted this privilege of being an unpaid government agent. See the Form 941 in the list? There it is. Okay, so there's the 941s that the indictment accuses Kent of failing to file when in fact he never filled out a 2678. He was accused of 12 counts of not filing these Form 941s on the indictment, page 3, paragraphs 4 and 6, and on page 4 in paragraph B, the charge. So I contacted Kent and asked him, did you ever fill out, sign, and submit a Form 2678 to request permission to be a withholding agent? And Kent said, no, I've never heard of the form. The federal regulations say the district director can require people in writing to keep books and records. 26 CFR 1.6001D, notice by district director requiring return statements or the keeping of records. The district director may require any person by notice served upon him to make such returns, render such statements, or keep such specific records as will enable the district director to determine whether or not such person is liable for tax under Subtitle A of the Code, including qualified state individual income taxes, which are treated pursuant to Section 6361A as if they were imposed by Chapter 1 of Subtitle A. So I asked Kent, did you ever receive any written notice from the Secretary of the Treasury or any district director to keep books and records? Kent said, no. No one ever ordered me to keep any books and records. So I asked Kent, did you ever receive any written notice from the Secretary of the Treasury or any district director that you must fill out and file 941s? And Kent said, no. No one ever ordered me to file the documents. Kent continued, as a matter of fact, for several years I had been writing the IRS requesting that they correspond with me and tell me what I had to do, if anything, and that if they did not respond to my request for documents and instructions, that I would take the position that I did not have to do anything regarding them. When Kent locates the copies of his correspondence described above, it will likely be posted and made available at the website KentHovindinnocent.com. Kent continued, and during the trial, my defense lawyer tried to bring this information out when the IRS agent was on the witness stand, but the judge interrupted this line of questioning and told my lawyer, the IRS agent is not on trial here, Kent Hovind is. And as soon as that happened, my defense lawyer turned into a kitten, and this vital information was never discussed any further. So the next form to examine is the SS4. It's an application for an employer identification number. And in section 14 of the application, it includes the duty to file Form 941. There it is, folks. SS4, and down over on the near the bottom, over to the right, is section 14. It says you must file 941s for every quarter. So I contacted Kent and asked him, Kent, did you ever fill out an application for an employer identification number on an SS4? And he said, no, I've never seen one. So this sent me to the next avenue, which was whether or not anyone who had ever worked at CSE had been told to sign a W-4 by anyone. Once a minister chooses to go down a corporate path and they acquire an employer identification number, then the IRS wants them to file an IRS Form 990 every year so they can keep track of their inner details of the corporate church. There's a 990. They want the employer identification number over there on the upper right. And you can see in the lower left that they want all this detail of gains and losses and a bunch of details about money coming in and going out of your corporate church. So I contacted Kent and asked him if he had ever filed an IRS Form 990, and he said no, he never has. On that Form 990, it clearly states the IRS wants a corporate ministry's EIN, and as we have already shown, Kent never acquired those numbers. I kept searching. I found IRS Publication 1828 in my research. It is the IRS's education publication for those who desire to start and operate a 501c3 corporate church. It contains some interesting statements I want you to read. The prosecutors tried to disparage Kent for operating a ministry that was founded as some unincorporated association or trust, and yet this is what I found in the Internal Revenue's own Manual 1828. Quote, churches and religious organizations may be legally organized in a variety of ways under state law, such as unincorporated associations, nonprofit corporations, corporation sole, and charitable trusts, end quote. And to educate the public about whether or not ministers are obligated to pay income tax, please read 26 U.S.C. 1402 C4, showing where ministers are exempt. Here it is, 26 U.S.C. 1402 C, trade or business. The term trade or business, when used with reference to self-employment income or net earnings from self-employment, shall have the same meaning as when used in Section 162 relating to trade or business expenses, except that such terms shall not include, and I'm skipping over 1, 2, and 2A through 2G and 3 to get down to 4 and bring it up. So, except that such terms shall not include 4, the performance of service by a duly ordained, commissioned, or licensed minister of a church in the exercise of his ministry, or by a member of religious order in the exercise of duties required by such order. As a minister of the gospel, Kent never owed the income tax, despite all past, present, or future false allegations, claims, or demands against him. Kent's ministry was and still is winning souls for the kingdom through creation science evangelism and dinosaur adventureland. Kent has even waived all rights or benefits of the Social Security system in 1974 upon his ordination by withdrawing the Social Security number that was acquired by his parents when he was a minor. And what does this mean when somebody does that? The Government of Health and Human Services letter. Next are 2 excerpts from a response letter from Penny Payton, a claims representative of the Social Security Administration, who in January 10 of 1986 responded to Jerome T. Shifen of Hudson, South Dakota, with answers to his questions. My copy of this letter will be on KentHovindinnocent.com. The following 2 statements within that response letter shed massive light on the Social Security system and how it links to the Internal Revenue Service's taxable income. Penny Payton said, Social Security is a voluntary system in that no one is required to get a number, and a person with no Social Security number would have no taxable income. Internal Revenue Manual 9.1.3.3.2.1 talks about avoidance distinguished from evasion. Title 26, 7201. Avoidance of taxes is not a criminal offense. Any attempt to reduce, avoid, minimize, or alleviate taxes by legitimate means is permissible. The distinction between avoidance and evasion is fine, yet definite. One who avoids tax does not conceal or misrepresent. He or she shapes events to reduce or eliminate tax liability, and upon the happening of the event makes a complete disclosure. Evasion, on the other hand, involves deceit, subterfuge, camouflage, concealment, some attempt to color or obscure events or to make things seem other than they are. I don't believe when Kent became a minister that he did so merely because the IRS had already declared ministers and ministries were exempt from taxes. I believe Kent became a minister of the gospel because he wanted to win souls for the kingdom. Becoming a minister of a ministry happened to be tax exempt because the laws follow the Constitution. Tax avoidance is legal. It always has been and hopefully always will be. What is illegal is slander and libel and malicious prosecution when public servants falsely claim that a tax-exempt ministry is a business and attack the ministry with the delegated powers of the people with 58 false charges. Do you need more proof? How about 26 U.S.C. 3121B8A? Here we go. 26 U.S. Code Section 3121 definitions. A. Wages. For purposes of this chapter, the term wages means all remuneration for employment, including the cash value of all remuneration, including benefits, paid in any medium other than cash, except that such terms shall not include A. 1 through A. 23, and B. 1 through B. 7 is removed for space, so this is B8A. Here we go. Services performed by a duly ordained, commissioned, or licensed minister of a church in the exercise of his ministry. So wages constitutes a whole long list of things, except that such terms shall not include this really long list, and way down at the bottom is 8A. So services performed by a duly ordained, commissioned, or licensed minister of a church in the exercise of his ministry is not wages. So, does anyone out there think I'm making this stuff up? Try this one out. 26 U.S.C. 3401A9. That says wages. For purposes of this chapter, the term wages means all remuneration other than fees paid to a public official, which that in itself is a strange sidebar, for services performed by an employee for his employer, including the cash value of all remuneration, including benefits, paid in any medium other than cash, except that such terms shall not include remuneration paid. A1 through A8 is also removed, and here's A9. For services performed by a duly ordained, commissioned, or licensed minister of a church in the exercise of his ministry. The big questions. Is there any question in anybody's mind whether or not Kent Hovind is a minister of the gospel of Jesus Christ? Some estimates are around 500,000 or more souls led to the Lord through Christian Science evangelism ministry. Is there any question in any reasonable person's mind as to whether or not the IRS has already declared that ministers and ministries are tax exempt? Does anybody actually wonder if Kent Hovind desired to become a Christian minister as a 16-year-old because he read the Internal Revenue Code and found where ministers are tax exempt? I don't. Many years ago, the IRS began to use their false claims that Kent owed an income tax to be the initiation point against him and the ministry assets that they later seized and sold. Now back to the Internal Revenue Manual 1828, recognition of tax-exempt status. Automatic exemption for churches. Churches that meet the requirement of IRC Section 501c3 are automatically considered tax exempt and are not required to apply for and obtain recognition of tax exempt status from the IRS, end quote. Now that phrase meeting the requirement means nonprofit. Further, this Internal Revenue Manual 1828 states, quote, although there is no requirement to do so, many churches seek recognition of tax-exempt status from the IRS because this recognition assures church leaders, members, and contributors that the church is recognized as exempt and qualifies for related tax benefits. Now for the issue of withholding or failing in an obligation to withhold. Most domestic Americans working in domestic American companies sign and turn in and thus begin to work under a W-4 that their employers hand them out of custom, habit, or policy at the beginning of their employment without reading the federal statutes and regulations that govern the submission of a W-4. There's probably somewhere around 60 million domestic workers in America right now working under a W-4 that was handed to them and induced upon them as a condition of employment. that they then signed and handed back to the employer, and yet they have never read even one federal statute or one federal regulation to see if they were actually required to do so in the first place. Now, since withholding occurs as a deduction from people's payroll, I entered the words payroll deduction agreements into Google and found Internal Revenue Manual 5.14.10.2. And here is the pertinent contents. Look at 5.14.10.2.2. Here it is. Private employers are not required to enter into payroll deduction agreements. Now, I'm willing to bet you have never seen that Internal Revenue Manual quote posted on the wall of a company or organization you work for in their law bulletin board. If you're not required to do something, then it is purely voluntary. So the issue really is it possible to unknowingly waive your rights? The United States Supreme Court in Brady v. United States says waivers of constitutional rights not only must be voluntary, but must be knowingly intelligent acts done with sufficient awareness of the relevant circumstances and likely consequences. U.S. v. Minker. Because of what appears to be a lawful command on the surface, many citizens, because of respect for the law, are cunningly coerced into waiving their rights due to ignorance. But I knew that the obligation to withhold, if it existed, would have to be collected at the source of earnings at the time it is paid. And this following statute is what I found when I searched for income tax collected at source requirement of withholding. Notice at paragraph A that there is a generality stated. In statutes, the variance or exception to the generality in the main body is usually found further down, sometimes way down at the bottom. In this statute, the exception was way down in letter P, so I had to excerpt out paragraphs B through O to bring up letter P to show it with A. 26 U.S. Code 3402, income tax collected at source. A. Requirement of withholding. 1. In general, except as otherwise provided in this section. Every employer making payment of wages shall deduct and withhold upon such wages a tax determined in accordance with tables or computational procedures prescribed by the Secretary. P. Voluntary withholding agreements. Certain federal payments. A. In general, if at the time a specific federal payment is made to any person, a request by such person is in effect that such payment be subject to withholding under this chapter, then for purposes of this chapter and so much of subtitle F as relates to this chapter, such payment shall be treated as if it were a payment of wages by an employer to an employee. Most domestic people working for domestic companies do not even understand that they requested withholding by signing and handing in a W-4. They ask for it to be done, and so the company agrees to do it. 26 U.S.C. 3402 has a regulation in the CFR. The next panel is it. Voluntary withholding agreements. 31.3402 P1. Voluntary withholding agreements. A. In general, an employee and his employer may enter into an agreement under 3402B to provide for the withholding of income tax upon payment of amounts described in paragraph B1 of 31.3401A3 made after December 31st, 1970. An agreement may be entered into under this section only with respect to amounts which are includable in the gross income of the employee under section 61 and must be applicable to all such amounts paid by the employer to the employee. The amount to be withheld pursuant to the agreement under 3402P shall be determined under the rules contained in section 3402 and the regulations thereunder. See section 31.3402C1, questions and answers 3, concerning agreements to have more than 20% federal income tax withheld from eligible rollover distribution within the meaning of section 402. B is form and duration of agreement. 1. Except as provided in subdivision 2, that's 2i, of the subparagraph, an employee who desires to enter into an agreement under 3402P shall furnish his employer with Form W-4, withholding exemption certificate, executed in accordance with the provisions of section 3402F and the regulations thereunder. The furnishing of such Form W-4 shall constitute a request for withholding. What is the legal definition of may? Black's Law Dictionary 6, Deluxe Edition. May. The word may usually is employed to imply permissive, optional, or discretional and not mandatory action or conduct. As a general rule, the word may will not be treated as a word of command. In construction of statutes and presumably also in construction of federal rules, word may as opposed to shall is indicative of discretion or choice between two or more alternatives. People may be thinking, isn't all work done for someone else always employee work? That would be erroneous thinking because of the federal regulation at 26 CFR 31.3121 D2C. Down at C, it says, although a person may be an employer under this section, services performed in his employ may be of such a nature or performed under such circumstances as not to constitute employment. But the federal prosecutors chose to block the grand and trial jurors from knowing all of this information in the Hovind trial. The Buck Act, passed in 1940, authorized the federal government to reach into the domain of the states and impose a public salary tax act on citizens of the United States who were working for the federal government. In 1942, Congress passed the victory tax and W-4 withholding legislation, which was a temporary emergency measure to be in place for a 2-year period. In 1944, both the victory tax and the W-4 withholding legislation was repealed. What happened in 1945? Millions of dollars kept pouring in, and the government was pleasantly surprised that the people did not realize that they did not have to continue sending in a chunk of their paychecks. And it spread beyond those federal employees that were working in the 50 states to all the rest of the employment arena for the rest of the workers, and has not stopped since. 71 years later, the lack of knowledge of the real laws has snowballed into what exists now, with nearly everybody coerced into filing a W-4 because nobody reads the statutes and regulations on withholding. If you now work, or if you have ever worked under a W-4, did you sign the W-4 voluntarily? Did you sign the W-4 with knowingly intelligent acts of the federal statutes and regulations that govern and control withholding? Did you have sufficient awareness of the relevant circumstances and the likely consequences that the business you worked for was going to withhold some of your pay as if you were requesting it to be done? If you were told that you would not be hired unless you signed a W-4, were you aware that you could have reserved your rights by writing on the W-4, that you were being made to sign the W-4 under duress and under threat of loss of the job if you did not sign it? It is my main goal to show the public how fraud was used against the Hovinds, not necessarily to teach the 60 million plus American domestic workers how to stop withholding if they believed they were coerced or tricked into signing a W-4 without the advanced knowledge that they were actually requesting themselves to be withheld on. But if a domestic worker who is working at a domestic company wants to know how to stop withholding because they now believe they were coerced or tricked into the voluntary nature of a W-4 by the language of 26 U.S.C. 3402 and 26 CFR 31.3402p, they would need to read further into the Secretary's Code of Regulations. 27 CFR 31.3402 P1B2 to see that one only has to inform the employer in writing with the language that they desire to stop withholding. Here it is. An agreement under Section 3402P shall be effective for such period as the employer and employee mutually agree upon. However, either the employer or the employee may terminate the agreement prior to the end of such period by furnishing a signed written notice to the other. This language is from the mouth or the pen of none other than the Secretary of the Treasury. I wonder how many domestic Americans actually knew of this above information before they signed and handed in a W-4 at their domestic job. The real issue, it wasn't that the workers at Creation Science Evangelism wanted to be withheld on and that Kit wasn't willing to do so. The lack of withholding was mutual. Whether or not they both knew of the existence of these above statutes and regulations is inconsequential. There were no foreigners working at CSE, and the domestic workers never gave Kent or anybody else any W-4 requesting it. There's one last issue about this 26 CFR 31.3402P that must be discussed. The withholding agreement, according to 26 CFR 31.3402P1A, must be applicable. And to be applicable, as we have already found, at least one of its originating statutes, Chapter 3, Subchapter A, Section 1441, 42, 43, or Chapter 3, Subchapter B, Section 1461, must apply. That is, some foreign entity or person, and must, according to unoverturned federal holdings, have matching enforcement regulations to be enforceable. In support of this premise that there is a distinction between foreigners and domestic workers, I found this excerpt in IRS Publication 515, Withholding of Tax on Non-Resident Aliens and Foreign Entities. A withholding agent is the person responsible for withholding on payments made to a foreign person. However, a withholding agent that can reliably associate the payment with documentation from a U.S. person is not required to withhold. So I thought, if there is a publication 515 instructing employers how to withhold on foreigners, then surely there must be an IRS publication instructing employers how to withhold on domestic employees. And so I searched the irs.gov publications website. Not only should there be an instruction manual, there should also be schedules, tables, and forms as well, if it were legal, valid, authorized, and proper according to the federal statutes and regulations. Below are my results. Search it for yourself and see if you can get anything different. Search results. This is what I found. You search for withholding of tax on domestic citizens and domestic entities, 0 results found. I searched for withholding of tax on domestic corporations. I got no results. I searched for withholding of tax on domestic citizens. I got no results. I did a search for withholding of tax on American citizens. I got no results. Don't give up. Keep trying. If you're trying this, keep at it. I searched for withholding a tax on domestic nationals. I got nothing. I even increased the search parameters by decreasing the number of words. I searched for withholding a tax on domestic, and there's nothing in the irs.gov website. IRS Senior Manager William Cash is quoted online to have said the following: considering that senior officials at the Internal Revenue Service are fully aware that that there is no law currently in existence making a U.S. citizen liable for or required to pay either the income tax or the Social Security employment tax, only a truly generous citizen would, upon discovering this, continue to voluntarily donate these taxes to the government by allowing them to be withheld from his paycheck on a 100% voluntary W-4 withholding agreement. But then again, the IRS would be dead in the water without the voluntary compliance of employers and employees have said so, and has said so all along, end quote. Now, while this is interesting, I personally did not interview Mr. Cash, and so I have no personal first-hand knowledge of this quote, but I considered it worthy enough to enter here. I am not here to tell you there is no law that requires domestic American workers, or domestic Americans working in domestic companies to pay the income tax. But I am here to ask this one question. If there truly was an income tax owed on all domestic Americans' domestic pay, then wouldn't there be domestic withholding statutes linked to withholding, domestic withholding enforcement regulations? Wouldn't there be domestic withholding forms? How about domestic withholding schedules and domestic withholding instruction manuals? The foreign withholding statutes, 26 U.S.C. 1441, 42, 43, and 61, prove that foreigners owe the tax. The foreign withholding enforcement regulations at 26 CFR 1441, 42, 43, and 61 prove that foreigners owe the tax. The foreign withholding form 1042S proves that foreigners owe the tax. The foreign withholding 1042S schedules prove that foreigners owe the tax. And the foreign withholding instruction manual 1042S, IRS publication 515 and 519 prove that foreigners owe the tax. Cognitive dissonance is usually what happens when you learn something new that opposes old beliefs. Well, this is how it all starts. People begin with limited information, and then they pass on that limited information, believing that what they are passing on is a totality of what can be learned about a topic. Well, then it begins to take on power and momentum all by itself. Soon, especially after decades of habit, custom, policy, and conformity, people rarely, if ever, go back to the roots and research the origins of it all to actually see if things apply to them. Those people who are in charge of withholding pay in domestic companies from domestic workers rarely, if ever, actually know about the complete truth of this issue, and as such, need to be treated with kindness and patience. They are almost always good-natured, desiring to be helpful, willing to learn new things, and usually do their job to the best of their present, if even greatly limited, knowledge. They also generally operate from a position where they believe they are obeying the laws as they presently misunderstand it, and as a result of that, if you were to choose to give them your written letter to stop withholding, according to the Secretary of the Treasury's own regulations, they may be resistant to change those customs, policies, patterns, and habits. And that is why you will need to work on calmly, respectfully, gently, and carefully coaching them into a new understanding if you are going to succeed in ceasing withholding from your pay. So getting back to the scent trail on obligations to withhold, I began searching in the laws of for the 501c3 tax-exempt status forms to see if there was any obligation there, and this is what I found. Here's Form 1023 for religious nonprofits, and here's the Form 1024 for most other nonprofits. And these are forms that these are the applications for recognition of exemption. After extensive research, I finally found the law that requires all ministers who want to start a church, a mission, or a ministry to first file for corporation status and then complete and file the IRS Form 1023 requesting tax-exempt status, and then sign and file S4 and 2678 to start withholding pay and file Forms 941 quarterly. The next panel is that law. That's right. There is no law. There is no law in existence that requires any minister who wants to start a ministry, a mission, or a church to incorporate or file for corporate status to begin with, and then file a request to be a withholding agent on Form 2678, and then file for an employer identification number on Form SS4, and then file for tax exempt status on the Form 1023, and then file quarterly 941s on the ministry's workers, and file Form 990s yearly to disclose all the internal church business to the government. There is no law requiring it, period. The prosecutors used implication against Kent, and it worked. They implied that Kent was obligated to do these things when no law required it in the first place. What I did find is this. I found that in 1954, Lyndon B. Johnson, then a senator, and his fellow co-sponsoring congressmen desired to squelch the mouths and sermons of pastors to their congregations because they felt that pastors held too much influence on how the church members voted in elections and spoke out against cultural degradation, that is, making things against God's law legal in America. So he authored the 26 U.S.C. 501c3 statute language so that a minister who wants government recognition by license could apply for 501c3 corporate status with the added promise that the contributions donated to them could be written off on people's tax returns, but those doing so would be contractually waiving their full, unfettered First Amendment rights. It's like joining the U.S. Marines. People can voluntarily apply to join the Marines. If the United States Marines believes you qualify as a decent recruit, they'll let you join. But once you take the oath, you lose your full access to your constitutional rights until the end of your enlistment contract because you waived them and submitted yourself to the orders of the chain of command and a much more strict form of law called the Uniform Code of Military Justice, and you better not try to claim your First Amendment rights to challenge your drill instructors or anyone else in authority, or you will get a very rude and brutal awakening. This is Guardian Trust and Deposit Company versus Fisher, a Supreme Court case. An individual may be under no obligation to do a particular thing, and his failure to act creates no liability. But if he voluntarily attempts to act and do the particular thing, he comes under an implied obligation in respect to the manner in which he does it. Well, Kent never volunteered to be a withholding agent. He never volunteered to turn his ministry into a corporation, and he never volunteered to ask the government for tax-exempt status that he knew the ministry already possessed under the First Amendment. This is a quote pulled directly from Video 2's California Bankers Association versus Schultz. Corporations can claim no equality with individuals in the enjoyment of a right to privacy. They are endowed with public attributes. They have a collective impact upon society from which they derive the privilege of acting as artificial entities. The federal government allows them the privilege of engaging in interstate commerce. Favors from government often carry with them an enhanced measure of regulation. So what changed? If a minister chooses to apply for corporate status first and then asks for the 501c3 tax-exempt privilege on IRS Form 1023, and it is granted, the IRS then lawfully holds the superior power to penalize people and remove that tax-exempt status qualification and protection over their heads if they fail to obey the numerous contractual requirements, or if they preach for or against any particular person who is running for public office at any level or branch of service, or if they preach against public policy that runs contradictory to the Word of God. I searched online for a government-generated 508 church notification form and discovered that there isn't one. If you start a legitimate church, mission, or ministry, and you choose to not incorporate, choose to not file for 501c3 status on the IRS Form 1023, then not file for 2678 status and not file an SS4 for an EIN, then your church, mission, or ministry already is 508 tax immune. What else I found is that in addition to no requirement to file all these forms, I found absolutely no requirement for any 508 First Amendment protected free church, mission, or ministry to have or acquire a church building, hold weekly church services, or even to preach sermons. And yet, the federal prosecutors elicited the testimony of former workers of CSE to try to show that CSE did not have a church building, did not hold weekly services, and that Kent Hovind did not preach weekly sermons to allege and imply to the jury that CSE was not therefore a legitimate ministry. Literally, hundreds of thousands of people have been ministered to by Kent over the last couple of decades. Now, I don't know about you, but I know street preachers and street ministers who have no church building and they have no weekly services. And yet they minister to the homeless, sidewalk pedestrians, people in the park, all as the Lord leads, and they already are 508 immune. The federal prosecutors stated in their indictment, page 2, paragraph 2, that Kent was operating a children's theme park. Disney World is a children's theme park. Six Flags is a children's theme park. Creation Science Evangelism's Dinosaur Adventureland has always been and always will be a ministry to bring souls into God's kingdom. Kent knows the kids learn better when they're having fun experiencing the principles of God's laws. That is why the prosecutors had to avoid certain words and use other words to paint a strictly commercial picture. And why trade a right for a license? So next is a little American history. The United States Constitution has 7 articles. The U.S. Constitution has 27 amendments. The first 10 amendments are called the Bill of Rights, and the First Amendment states the following. First Amendment, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievance. So let's take these 6 clauses one at a time. First Amendment, first clause, Congress shall make no law respecting an establishment of religion. Congress is prohibited from writing and passing any legislation that gives deference, priority, preference, special favor, or benefit to any religion over another religion. The founders wrote this because King George III preferred the Church of England over all others and prosecuted preachers and followers who did not follow the exact teachings of his favored church. First Amendment, second clause. Congress shall make no law prohibiting the free exercise thereof of any religion. And yet, this is exactly what the federal prosecutors have done to Kent by prohibiting his free exercise to run and operate Creation Science Evangelism exactly how he saw fit, because Kent did not waive his rights and request any diminished tax-exempt corporate status for himself or the CSE ministry. First Amendment, third clause. Congress shall make no law prohibiting or abridging the freedom of speech. Congress can pass no legislation that would diminish, squelch, suppress, or hinder the full expression of speech, which includes many forms of expression other than mere words. What I'm doing here for Kent is well within the full and free exercise of my First Amendment speech rights. Later in video 8, I'm going to ask you to exercise your freedom of speech and redress for Kent. First Amendment, fourth clause. Congress shall make no law prohibiting or abridging the freedom of the press. Now, since this video presentation is being made electronically and stored in various audio and visual storage formats and not necessarily just printed out on paper, it too is fully protected by this clause of the First Amendment. First Amendment, fifth clause. Congress shall make no law prohibiting or abridging the right of the people peaceably to assemble. This prohibition actually works to secure our rights of travel, along with the Fifth Amendment, because if the rights of travel were to be diminished or halted, it could prohibit our right to peaceably assemble. Later, we will in essence be assembling from across this nation for a common cause, even though it may be electronically, under the banner of Christ, to exercise our rights for Kent Hovind and the CSE ministry's benefit. First Amendment, sixth clause. Congress shall make no law prohibiting or abridging the right of the people to petition the government for a redress of grievances. This video series is exactly what is protected here. We must unite together and raise our collective voices to the proper public servants to declare that we do not approve of the way that the machinery and powers of our government were misused to falsely prosecute Kent and Joe Hovind, and we must order that proper remedial action be taken in their behalf. Let's go to the 18th Amendment for a moment. Section 1, Section 2, and Section 3. Section 1 is, after 1 year from the ratification of this article, the manufacture, sale, and transportation of intoxicating liquors within the importation thereof into, or the exportation thereof from the United States and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. Congress in the several states shall have concurrent power to enforce this article by appropriate legislation. In Section 3, this article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. So this is the 18th Amendment that outlawed alcohol beverages. Now, why am I using this example? You'll see in a moment. In terms of what it has cost the American public and society as a whole in loss of life, in loss of health, in loss of marriages and family relationships, in loss of work time, nothing has been worse than alcohol. Not only does it take money away from the family, but it causes people to do things that they otherwise would not do. Trying to escape the pains of life with alcohol will only result in more pain later, because after the effects of alcohol wears off, the emotional pain returns, and now the drinker has even less money to deal with life's demands and bills. DWI deaths alone number over 1 million lost lives since cars were invented. That's at least 1 million destroyed, damaged, hurting families, and untold billions of dollars in beneficial earnings lost unnecessarily. But people just had to have their alcohol. So they pushed their legislators to repeal the 18th Amendment, and about 21 years later, they finally did. That repealing act became the 21st Amendment, and it simply states, quote, the 18th Amendment is hereby repealed, end quote. But notice both amendments, when you read the constitutions, you go get a copy, you look at it in the libraries, both amendments are still posted. The 21st repealed the 18th, but they're both there. And why is that significant? Why did I cover this? Well, if you'll read all 27 amendments, you will find that there is no repealing act to the First Amendment. That means the First Amendment is still in full force and effect for all those who want to exercise their rights to create and operate any ministry they want in any state they want. Remember that case law quote from California Bankers Association versus Schultz in video 2? First Amendment freedoms are delicate and vulnerable. They need breathing space to survive. Quoting NAACP versus Button. Kent's First Amendment freedoms were stolen when they attacked the ministry and filed their false charges against him. So getting back to the 501c3 status issue, for 165 years in America, that is from 1789 to 1954, there were no 501c3 status available as an option for churches, missions, or ministries. Yet tens of thousands of tax-immune local, state, national, and international ministries were created and continued growing. I kept digging. I found that churches, missions, and ministries were already exempt under the First Amendment, and I found that the charitable contributions made to them could already be deducted from the donor's taxes. The only thing that changed under 501c3 was the prohibition against speaking out for or against political issues or candidates and resisted ungodly cultural slide. Those free churches never needed any 501c3 status to begin their ministry or to continue operating. How do I know? IRS publication 557 says so. Here's this direct quote. Quote, some organizations are not required to file Form 1023. These include churches, interchurch organizations of local units of a church, conventions or associations of churches, or integrated auxiliaries of a church, such as a men's or women's society or youth group. These organizations are exempt automatically if they meet the requirements of Section 501c3. And again, 501c3 means charitable for nonprofit ministry. So where does the law state that churches are automatically tax exempt? Well, that's 26 U.S.C. 508c1a. It states, special rules with respect to Section 501c3 organizations. A. New organizations must notify a secretary that they are applying for recognition of Section 501c3 status. B. Presumption that organizations are private foundations. I'm not going to read that. Then down to C, exceptions. Oh, they always put the exceptions way down at the end. C, mandatory exceptions. Sections A and B shall not apply to what? A, churches, their integrated auxiliaries, and conventions or associations of churches. So A and B, that is the requirement to notify the IRS that you're applying for 501c3, it doesn't apply to churches. Where does it say that people's contributions to churches are already tax exempt? IRS Publication 526. Quote, you can deduct your contribution only if you make them to a qualified organization. What's the wording on this? To become a qualified organization, most organizations other than churches and governments, as described below, must apply to the IRS. End quote. There it is in black and white. Churches already are qualified organizations and have been since 1913. Okay, this is Internal Revenue Publication 526. And then it goes on to say what a qualified organization is. Watch very carefully how they word their language. This is a direct quote. Quote, most organizations other than churches and governments must apply to the IRS to become a qualified organization, end quote. And then Publication 526 goes on to list commonly understandable organizations that meet the loose standards for tax deductibility. Internal Revenue Publication 526 then continues on its page 3. Examples. The following list gives some examples of qualified organizations. Churches, a convention or association of churches, temples, synagogues, mosques, and other religious organizations, end quote. So they give you the examples right there of organizations that are already qualified organizations, and there's churches at the first of the list. What did retired IRS Senior Revenue Officer Steve Nestor state about this particular issue? Quote, I am not the only IRS employee who's wondering why churches go to the government to seek permission to be exempted from the tax they didn't owe to begin with, and to seek a tax deductible status that they've always had anyway. Many of us have marveled at how church leaders want to be regulated and controlled by an agency of government that most Americans have prayed would just get out of their lives. Churches are in an amazingly unique position, but they don't seem to know or appreciate the implications of what it would mean to be free of government control, end quote. From the foreword of In Caesar's Script by Peter Kershaw. That's where that is found at. Since 1954, around 98% of all churches, missions, and ministries now have 501c3 voluntarily waived their First Amendment rights and accepted licenses. There is no law that obligates anyone to fill out the forms and apply for any corporate, tax-exempt, withholding agent, employer status, but if they do, then they are voluntarily contracting away their rights and freedoms to become obligated to do so, and under those specific circumstances alone, they can be penalized for failing to withhold if they hire foreigners. Check out what I found near the end of my research cataloging. Internal Revenue Manual 9.1.3.3.3.1.3. This is 26 U.S.C. 7202, the statute of limitations. The position of the Department of Justice, Tax Division, is that the statute of limitations for violations of 26 U.S.C. 7202 is 6 years, as provided in 26 U.S.C. 6531, subparagraph 4. Note, 2 federal district courts have concluded that the statute of limitations is 3 years, end quote. This is right out of the Internal Revenue Manual. So how would there be a disparity between 6 and 3 years? I'm going to show you. What does this mean? The 12 counts of 26 U.S.C. 7202 willful failure to withhold taxes was for the 3 years of 2001, 2002, and 2003 in the Hovind case. The indictment was filed July 11th, 2006. The DOJ has a policy, not law, that the statute of limitations for violating 7202 is 6 years per 26 U.S.C. 6531, subparagraph 4. Yet, 2 district courts held the statute of limitations as 3 years. That variance made me have to check out what 26 U.S.C. 6531, subparagraph 4 said to see if there's anything like an exclusion, exemption, or exception. So I went to 26 U.S.C. 6531, subparagraph 4, and this is what it says. 6531 says periods of limitations on criminal prosecutions. no person shall be prosecuted, tried, or punished. Notice how they delineated between those two. Prosecuted, tried, or punished for any of the various offenses arising under the Internal Revenue laws unless the indictment is found or the information instituted within 3 years next after the commission of the offense, except that the period of limitation shall be 6 years. And then 6531 lists several exceptions where this statute of limitation swings back to 6 years in 1 through 3, and then it gets to 4. So here we are, 26 U.S.C. 6531, subparagraph 4 is a doozy. 4 says, for the offense of willfully failing to pay any tax or make any return, the statute of limitations is 6 years. And we certainly know that Kent was charged with willfully failing to pay tax and file 941s. But then this list of exceptions to the 3-year statute of limitation that takes the statute of limitation back out to the 6-year limit then reverses itself once again to list the exception to the exception that brings the statute of limitation back down to 3 years. Only lawyers write like this. So here it is. Quote, other than a return required under authority of Part 3 of Subchapter A of Chapter 61. So then I had to go look that one up to see this. So the exception to the exception is Chapter 61, Subchapter A, Part 3. What do you suppose I found in this? Chapter 61 is Information and Returns, and that's sections 6001 to 6117. And Chapter 61 has 2 subchapters, that is Subchapter A and B. A is Returns and Records from 6001 to 6098. Subchapter B is Miscellaneous Provisions from 6101 to 6117. So I started in A, like it said, and found this, Subchapter A, Returns and Records. So then I found Part 3, because it said to go to Part 3, so I went to Part 3. It says Information Returns from 6031 to 6060. And then found that Part 3 has 6 subparts labeled A through F. So finally we're in Chapter 61, Subchapter A, Part 3, Subpart A, and that is information concerning persons subject to special provisions, subsections 6031 to 6040. So I began there at the very first one to read from section 61, and I was planning on going all the way through to 6040, but didn't have to. 6031 is partnership income, 3 years. So it went from 3 out to 6 and back down to 3 because this is the exception to the exception. Partnership income is 3-year statute of limitations. 6032, banks and common trust funds. Okay, so Kent didn't own a bank or a common trust fund. That's back down to 3-year statute of limitations. And the next one just blew me away. 6033, returns by exempt organizations. Now we're talking. Let's read 6033 to see what it contains. So we run this to its end and we find A, organizations required to file in general. Remember what I told you about in general? They start off with the in general, and then they list the exceptions. So here it goes. A, organization required to file 1 in general, except as provided in paragraph 3, every organization exempt from taxation under Section 501A shall file an annual return. 3 is the exceptions from filing. A, mandatory exceptions. Does that look like optional to you right there? Nope. It's mandatory exceptions. Paragraph 1 shall not apply to bingo churches, their integrated auxiliaries and conventions or associations of churches, end quote. So, after all is said and done, the prosecution of Kent Hovind for the 12 charges of failure to withhold actually had a 3-year statute of limitation, not a 6-year statute of limitation, and therefore the first 11 of those 12 charges were completely time barred and thus illegally prosecuted against Kent. Now, the trial took place during the 3-year limit to the 12th quarter in question. Remember how they charged him with 12 counts? And so the 12th quarter, the statute of limitation took place, the trial took place during that 12th quarter. And it certainly could have been determined by an honest and moral judge that even the 12th count should be dismissed by being time barred. Kent did not have an honest and moral judge in this sham kangaroo trial. In addition to all of this, the workers at CSE filed and paid whatever tax they believed they owed as private workers or subcontractors. A few even came to trial and testified about this, but these facts were minimized because the main issue was to have Kent found guilty of not filing those 12 Form 941s, even though he had not contracted to do so and never had any foreigners work at CSE. So the next two United States Supreme Court cases I want you to read quotes from involve substantive rights and our freedom to exercise them. The first is the case of Murdoch versus Pennsylvania, 319 U.S. 105, and the second is the case of Shuttlesworth versus Birmingham, Alabama. And this is what they say. Mr. Murdoch and others were walking down sidewalks and going up to residential homes, ringing their doorbell or knocking, and engaging the occupants who answered about the religious material they were attempting to spread in the community of Jeannette, Pennsylvania. Neither Mr. Murdoch nor any of the members in their congregation purchased the license to solicit business door to door from the officials of Jeannette because they weren't in business. They were arrested, charged, found guilty, and fined. The Pennsylvania Supreme Court upheld their convictions, but the United States Supreme Court took the case under certiorari. The city of Jeannette and the state of Pennsylvania were falling beneath the minimum floor of the rights that we, the people, have. The Supreme Court ruled that, quote, no state may convert a secured liberty into a privilege and issue a license and fee for it, end quote. Governments are to refrain from encroaching on the religious liberties of the people. The United States Supreme Court declared that First Amendment rights are in the preferred position, meaning that fundamental rights have prerogative over other laws that may be enacted. Likewise, the IRS should not have squelched and destroyed creation science evangelism due to this federal prohibition, yet they did. Now for Mr. Shuttlesworth. He was a civil rights lawyer and a good one at that. He sued and won against the city of Birmingham, Alabama 3 times on 3 separate issues that they were dead wrong on. One of those wrong issues was the city's ordinance prohibition against unlicensed marches. One day, Mr. Shuttlesworth and several other black men were walking down the sidewalk. Because the gentlemen were walking in step, the local police viewed it as a march, and the license had not been previously purchased. So the police, looking for an opportunity to do their part to put an end to the civil rights movement, arrested Mr. Shuttlesworth and the others, and were summarily found guilty and fined for their heinous acts. The city court system, the state of Alabama, Court of Appeals, and the lower federal court system all ruled against Mr. Shuttlesworth, but he did not give up. When this case got to the United States Supreme Court, they ruled, if the state does convert a right into a privilege and issue a license and charge a fee for it, you can ignore the license and fee and engage in the right with impunity. I believe Kent Hovind should be allowed the same liberty as Mr. Murdoch and Mr. Shuttlesworth in not having to buy a 501c3 license to operate a First Amendment protected ministry. How about you? The word failure to do something denotes an obligation to do the thing. Kent could not fail to kneel to the Queen of England because Kent is not obligated to kneel to the Queen of England. Likewise, Kent was not obligated to withhold, therefore he could not have willfully failed to withhold. Remember that the Supreme Court ruled, no state may convert a secured liberty into a privilege and issue a license and fee for it. And if the state does convert a right into a privilege and issue a license and charge a fee for it, you can ignore the license and fee and engage in the right with impunity. The totality of absence of obligation shown in the previous 180 panels eliminates the evil intent or mens rea, the legal term of criminal mind, from the omission of withholding, which negates the willfully portion of the page 4 accusation in the indictment and the statute language, especially in light of the U.S. Supreme Court case of Cheek versus United States. In Cheek versus United States, the Supreme Court held that a defendant on trial for non-payment of taxes must be acquitted if the jury finds that he sincerely believed that he was not violating the law, regardless of whether the defendant's belief was objectively reasonable. In this interpretation of statutes levying taxes, it is the established rule not to extend their provisions by implication beyond the clear import of the language used, or to enlarge their operations so as to embrace matters not specifically pointed out. In case of doubt, they are construed most strongly against the government and in favor of the citizen. This is Gould versus Gould. Internal Revenue Manual 9.1.3.3.2.2.3. 2008. This is 26 U.S.C. 7201, willfulness. Now, Kent was not charged with 7201. However, they defined willfulness in this manual, which applies to all of Title 26. Quote, to satisfy the third element of 26 U.S.C. 7201, the attempt to evade or defeat a tax or the payment thereof must be willful. Willfulness is defined as the voluntary intentional violation of a known legal duty. Well, did Kent have a known legal duty as a minister? I think I've pretty well proven in video 3, no. Mere understatement of income and the filing of an incorrect return does not in itself constitute a willful attempt to evade tax. Absent an admission or confession, willfulness is rarely subject to direct proof and generally must be inferred from the facts and circumstances. Willfulness may be inferred from any conduct that the likely effect of which would be to mislead or conceal, such as that exemplified in spies. This definition of willfulness applies to all Title 26 offenses where willfulness is an element, unless stated otherwise. End quote. So this entire definition from here to here is in this Internal Revenue Manual, and willfulness was charged against Kent in 7202. Do you remember in video 1 that I told you there were 31 reasons why Kent is not guilty of these first 12 counts of failure to withhold? Here they are, in order of appearance. I believe I've got this all correct. Number 1, 26 U.S.C. 7202 has no enforcement regulations specifying who is required to withhold. Number 2, mandatory withholding is only for foreigners per 26 U.S.C. 7701 A16 at 26 U.S.C. 1441, 1442, 1443, and 1461. Remember that definition? No, number 3 is no domestic workers ever gave Kent or CSE a W-4 per 26 U.S.C. 3402 P1A and 26 CFR 31.3402 P1A. Number 4, Kent never filed a Form 2678 requesting to be a withholding agent. Okay, number 5, Kent never filed an SS4 requesting to be an employer. Number 6, Kent never filed a 1023 asking for IRS recognition. Number 7, the First Amendment protects all ministries as tax exempt by prohibiting all laws restricting them. Number 8, the First Amendment protects all ministers as tax exempt by prohibiting all laws restricting them. Number 9, there is no repealing act to the First Amendment. Number 10, the Secretary of the Treasury never wrote Kent with any letter ordering him to keep books and records or to withhold on anyone. Number 11, no district director ever wrote Kent with any letter ordering him to keep books and records or to withhold on anyone. Number 12, IRS Publication 1828 says churches and other ministries are tax exempt. Number 13, 26 U.S.C. 1402 C4 says ministers are tax exempt. Number 14, Kent waived all benefits and gave their Social Security number back, which severs the relationship. Number 15, an official letter from Social Security says someone with no Social Security number would earn no taxable income. Number 16, Internal Revenue Manual 9.1.3.3.2.1 says making events to create tax avoidance is legal. Number 17, 26 U.S.C. 3121 B8A says ministries are tax exempt. Number 18, 26 U.S.C. 3401 A9 says ministers don't earn wages. Number 19, Internal Revenue Manual 5.14.10.2 says private employers are not required to enter into payroll deduction agreements. Number 20, the Supreme Court in Brady v. United States says that waivers of rights must only be voluntary acts done with sufficient awareness of the consequences. Number 21, 26 CFR 31.3121 D2C says not all work for others is employment. Number 22, IRS Publication 515 is for foreign withholding. Number 23, IRS publications for mandatory domestic withholding cannot be located. Number 24, IRS Publication 557 says churches are tax exempt. Number 25, 26 U.S.C. 508 C1A says ministries are tax exempt. Number 26, IRS Publication 526 says churches are already qualified organizations. Number 27, Internal Revenue Manual 9.1.3.3.3.1.3 says the statute of limitations for prosecuting accusations of 26 U.S.C. 7202 are 3 years for ministers or ministries because of the 26 U.S.C. 6033 A13A I exception to the 6 years. Number 28, the workers who did work at CSC paid their own taxes from their earnings. Number 29, the Supreme Court says that no state can convert your liberty into a privilege and charge a fee for it, but if they do, you can ignore the license and fee and exercise the right with impunity. Number 30, the Supreme Court says in the cheat case that the defendant must be acquitted if he sincerely believed he was not violating the law. And number 31, Internal Revenue Manual 9.1.3.3.2.2.3 says that willfulness requires that Kent would have had to conduct a voluntary, intentional violation of a known legal duty. And of course, numbers 1 through 30 above pretty well prove that Kent had no known legal duty to withhold. Therefore, the filing of the 12 counts of failure to withhold was pure, unadulterated fraud. Remember that definition of fraud in video 2? Here's a quick review. Fraud is a false representation of a matter of fact, whether by words or conduct, by false or misleading allegations, or by concealment of that which should have been disclosed. Anything calculated to deceive, whether by a single act or combination, or by suppression of truth, or suggestion of what is false, and comprises all acts, omissions, and concealments involving a branch of legal or equitable duty and resulting in damage to another. So, did the Hovind prosecutors declare 12 false representations of a duty to file 941s when Kent had not contracted to do so? The answer is yes. Did they falsely represent that Kent failed to withhold on people when foreigners never worked there and when none of the domestic people gave Kent a Form W-4 asking for withholding? The answer is yes. Did the federal prosecutors use misleading or false allegations? The answer is yes. Did the federal prosecutors conceal that which should have been disclosed? The answer is yes. Did the federal prosecutors choose their allegations in a calculated way to deceive the jury? The answer is yes. Did the federal prosecutors suppress the truth? The answer is yes. Did the federal prosecutors suggest what was false? The answer is yes. Did the federal prosecutors commit acts, omissions, and concealments involving a branch of legal or equitable duty? The answer is yes. And finally, did the federal prosecutors' actions and words damage Kent? The answer is yes. Because concealment of all these extrinsic facts was knowingly engaged in by the prosecutors to keep the jurors ignorant, they committed the criminal acts of fraudulent concealment, depriving Kent in counts 1 through 12 of his constitutionally protected rights of due process, which stripped the court of all subject matter jurisdiction to even file or try these charges against him. There is no crueler tyranny than that which is exercised under cover of law and with the colors of justice. That's U.S. versus Gennady. So in this video, number 3, have I proven to you that fraud was filed, entered, and used by the IRS agents and prosecutors in counts 1 through 12? If I have proven to you that fraud was used against Kent, then keep your critical thinking sharp and please now go to video 4 of the 8 series.